Good morning, dear students. I trust that you are all fine. So you are welcome to this criminal law class. I will leave about 5 minutes so that I will enable as many as are trying to join. And when it's exactly 8:05, I'll be back. So hold on and sit tight. So, okay, ladies and gentlemen, you're welcome to the class. You have the Zoom in such a way that you'll not be able to unmute until we begin to give you opportunity to ask questions. So, in the previous class, we looked at the general principles governing the defenses of justification and excuse, and then we were given the opportunity to ask questions. We are given an opportunity to ask questions. So today, I have also sent in advance my video on the plea of self-defense, one of the justification-based defenses. And then I've also sent a video on the plea of intoxication. And I said that these two should be, should listen to this in preparation for today's class. So first, I'm going to give opportunity for anyone who has any question on the plea of self-defense. Now, in the plea of self-defense, we looked at the lecture on the video looked at general principles governing the plea of self-defense. And we expect that students should be able to explain these general principles governing the plea of self-defense. And then also they should be able to discuss the plea of self-defense with statutory provision and decided authorities. So first of all, we look at the general principles. Then we went on to look at the conditions governing the plea itself. We looked at the conditions relating to the attack and the conditions relating to the defense. So that essentially is what that defense to criminal liability part 2 is all about. So now I'm going to give you opportunity to ask questions on the plea of self-defense. Remember, the way we go about it is you will raise up your hand, and I will enable, when I see your hands raised up, I will then enable you to unmute. You will then unmute and ask your questions. The lecture is also live on YouTube. So your colleagues who may not be able to join after we have reached the 300 participant maximum can always go to the YouTube and also follow the lecture live and direct. So time for questions on the plea of self-defense. Please, I want to appeal to you also, very important, that you should not put on your video. You can see that my own video is off. I only put on my video at the beginning, when I came up initially. The video increases the load on the bandwidth, and we don't want to unnecessarily increase the load because that may impair our ability to hear ourselves very well. So it's time for questions. If you have a question, please raise up your hand. Yes, I can see Deborah James. So I'm going to ask you to unmute now. So you will unmute and ask your question. When you finish asking your question and I've provided an answer, then you will bring down your hand so that it will be easy for me to identify those that are still pending. So you can unmute now, Deborah.
Okay, thank you, sir. Good morning, sir.
How are you doing?
I'm fine, sir. Thank you. While I was listening to the video, so you gave a scenario whereby someone attacked someone and maybe pushing the person. You said that maybe the first was commensurate because maybe the person maybe slapped someone and you pushed the person and no harm was caused. But I was now thinking that what if someone slaps someone and you actually push the person and the person maybe is having maybe an health issue or falls down, the person dies from there, I wanted to ask, like, would the person be charged for murder or manslaughter, or what exactly would the verdict of the
court? That's an interesting question. Now, what is important in the plea of self-defense is the reasonableness of the force that is used in response to the attack or assault. If the response to the assault or attack is reasonable, then whatever happens, the person claiming the defense will be entitled to rely on it. Like the example you gave now, somebody slapped you and is coming to slap you again, and to prevent him from slapping you, you pushed him away. You try to shove him away, to prevent him from coming again and then he falls, and because he has a heart condition, he falls down and dies. Now, his death is not an intended conduct. So number one, you cannot be charged for murder because you did not intend to kill him. The kind of force that you use is not the kind of force that can cause grievous bodily harm or that can cause death. So because of that, you will not be liable for murder. Now for manslaughter, before you are liable for manslaughter, the rules are that you must have done something that is dangerous and something that is unlawful. Now, in this instance, your response in pushing him is not a dangerous act, and it is not an unlawful act because he was the one that first assaulted you, and you did what you did in self-defense. So if it's unfortunate to have a bad heart, and as a result of his bad heart, or his head is as strong as the shell or weaker than the shell of an egg, and he falls down and his egg breaks to pieces and he dies, then you are not responsible because, number one, your response to the attack was reasonable. It was proportionate. You had no intention of killing him. So you cannot, and you had no intention of inflicting grievous bodily harm. So you cannot be liable for murder. And then you can also not be liable for manslaughter because what you did was not unlawful and what you did was not dangerous at the same time. So if it now happens to die, then you have, your defense will avail you both ways. Okay. Ayomide Odubonojo. Ayomide Odubonojo. You can unmute now.
Okay, thank you, sir. Good morning, sir. So my question is, so you in the video you stated that there are certain crimes that can occur against the person that you can, that like instead of the principle of self-defense to be that you retaliate proportionately, that you can like jump straight to trying to kill the other person because of like what they're trying to do to you. So like one of the examples that you gave there was rape, right? So somebody is trying to harm you in that sense, right? So with self-defense, you also said that another person can try to help you, but they have to act proportionately. The thing is, would that other person, like in trying to help you, they kill the person, what defense would be available to the person? Or would they be not liable because of what has happened? Thank you,
Okay.
sir.
Now, let me rephrase it very well and be sure that I get your question very well. You said somebody was acting and aiding me to defend myself, okay? And what he was doing in the circumstances was proportionate and reasonable. And the person against whom he was trying to defend me, the person he was protecting me from, now attacked him and killed him. What would be the liability of the person that attacked and killed him? If that is your question, it would just be like the case of provoked assault. Now, generally, the criminal law does not allow you a defense to a provoked assault. You cannot say, if I slap your face and you slap me back, I cannot now slap you the third time and say that I'm slapping you because you slapped me. Why? Because I provoked the assault. So in the scenario that you gave, the person who now killed the person aiding me in self-defense would not be allowed to rely on a plea of self-defense because he was the one that created the circumstances in which the victim sought to help me. I could have been the one helping myself. So if I was the one helping myself, he now kills me. It's the same thing. He has no defense. But remember, the rule against provoked assault has one exception. And that exception is that if I'm the one that first assaulted you, I gave you a slap, and you slapped me back. I'm the one that first assaulted you. Now, let's assume that I slapped you. And instead of you slapping me back or pushing me or punching me, you now bring out a gun and you start shooting at me. And I start running around trying to evade the bullet. Now, if in that sense, I now happen to also have something that I can use to kill you. If unknown to you, I also have a gun, or I could get a gun nearby, and I now shoot you and kill you, I will have a right of self-defense because there's a provision, I think it's section 287 of the Criminal Code, that says that in that kind of situation, I will be allowed to raise a plea of self-defense, even though I am the one that initially provoked the assault, provided that my initial assault is not the type of assault that will have created a fear of apprehension of death or grievous bodily harm in the person that I am attacking, to now necessitating to want to respond in a commensurate force to overcome my threat and thereby kill me before my right to now defend myself arises. So if I was the one that provoked the assault, and if it is an ordinary assault, then no problem. The person is not allowed to respond in a way as to justify him using such force as will kill me, because that's another ordinary assault. But if he now reacts in such a manner, he now brings a gun and starts shooting at me, starts chasing me, and I'm not able to get a gun and shoot at him, I will be able to rely on the plea of self-defense, even though I was the one that started the assault, provided that my initial assault is not the type of assault that can cause death or, cause grievous bodily harm. I don't know if that answers you. Okay, so let me identify somebody. Omole Emmanuel. Unmute. Omole Emmanuel, you have to unmute. I've enabled you to unmute. You have to press the unmute. You have to press the audio button to unmute. Okay, if you don't know how to do that, let me go to somebody else. Akinyemi Precious Akindeji. Unmute. Akinyemi Precious Akindeji, I've enabled you to unmute.
Good morning, sir.
Yeah,
good morning, sir. So, when I was watching the videos, you said something about situations where you're allowed to use force, where force that even if you kill the other person, you won't be held accountable or liable for that crime. That's the part that I don't understand, sir.
Okay, now you can only do that if the initial attack on your person is such an attack as to create in you apprehension of death, or to make you feel that the person is going to grievously injure you. Like the example I gave just now. If I slapped you, I mean, that's an ordinary slap now. If you slap me back, that would be okay. But if I slap you and you now bring out a gun and you start shooting at me, it was ordinary play. I was playing with you. I was totally joking with you by slapping you. Now you are trying to kill me. If I get a gun and kill you, that killing is justified. Okay? So let me identify. So Akinyemi Precious, I've answered your question. So bring down your hand so that I'll be able to see the people that I need to attend to clearly. All right. So let me enable additional read one to unmute. Additional unmute.
Okay, sir. Good morning, sir.
There seems to be a lot of noise around you.
Okay, sir. Yes. Good morning, sir. Can you hear me, sir?
Quickly. Yeah, I can hear you.
Okay, sir. My question is in relation to the first question. So, in a case where I try to like defend myself against the person, like that is trying to like maybe slap me or maybe push me, and the person now falls down and hits his head on maybe something, and in the process the person now like die. What will be court? Will I be charged for murder or like manslaughter?
I've explained that now. I've explained that. I said the determining factor will be the level of force that you use in response to the assault on your person. If the level of force that you use, you can mute back your device so that we won't hear the background noise. If the level of force you use is reasonable in the circumstances, but the guy unfortunately falls down, maybe there was something around that he hit his head on, or maybe he's suffering from a medical condition and he dies. You will not be liable because number one, you will not be liable for murder because number one, you did not intend to kill him and you did not intend to cause grievous bodily harm. Number two, he was the one that assaulted you and you responded proportionately. Number three, he will not be liable for manslaughter because to be liable for manslaughter, you must have done something that is unlawful and at the same time that is dangerous, that is likely to, cause serious harm to others. In this instance, what he has done is not unlawful because he's trying to defend himself. And what he has done is just by merely pushing him. It's not ordinarily such a thing as is dangerous and likely to endanger human life. So on both grounds, like I said earlier, he cannot be liable for murder. He cannot be liable for manslaughter. He is not liable for anything at all. All right. Stephen Samuel Nwoba, on mute.
Yeah, good morning, sir.
How are you doing?
I'm fine, sir. So I have a number of questions here, but let me begin with
so you take them one after the other. After each one, you will mute. When I finish, I will unmute so that you can take the second one. Go ahead.
Okay, sir.
Unless you are sure that your background is not noisy.
No, it's not noisy, sir.
Okay, if your background is not noisy, then you can leave it on. Go ahead.
Okay, sir. The first one is with respect to the first question that Kenoshi asked. I want to put another question there, so I didn't get it. Now, in the scenario of rape, now let's assume that maybe someone, attempted to rape another, and then I want to know the position of the mental element that the menstruation. Let's say that the intention or the mental element or the intention by the rapist or the potential rapist is not to kill. And maybe the girl who just perceived that there could be the likelihood of maybe this Mr. Man trying to rape me in a way, drew out a stick or drew out a log of wood on me and then kills this particular potential rapist. So my question there is this. So what would be the test or the objective test that the court will use to determine the menstruation?
All right. You don't have to go to menstruation. The question you need to go to is whether an attempt to rape is sufficient to enable a victim to exercise a plea of self-defense that would justify inflicting the kind of harm that can cause death. Now, the starting point is section 65 of the section 65 of the Penal Code. It provides that when there is an attack which causes reasonable apprehension of death or grievous hurt, or rape or assault. So if somebody is trying to rape you, rape is a very, very serious offense. That is why rape attracts a punishment of life imprisonment, because it can cause grievous bodily harm. because the woman is trying to resist, the assailant is trying to have his way. In the process, he can hit the woman. In the process, a lot of people have been killed in the process of rape. So rape, the mental agony involved in rape, the violation of the person involved in rape, all that elevates rape to something that can cause grievous bodily harm or create apprehension of death. So that is why under the penal code specifically mention rape as a ground that can justify using force that can cause death. And although the criminal code does not say so, as I've explained now, rape, an attempt to rape is, an intention to cause grievous bodily harm. And if the assailant is trying to cause grievous bodily harm, or the victim apprehends death, on either of the two grounds, he can use such force as is reasonable, even if death ensues. So that is the answer to that first question. So go ahead if you have another one. Okay, I've enabled you to unmute because you may not be able to unmute yourself. So Wogba, you can unmute again. Yes. Quickly, because time is going on. I have a long list of people who wants to ask questions. Let's be snappy. I can't hear him again. Oh. Okay, let me go to somebody else. Obi Stanley Kenechi, unmute.
Okay, hello, good morning, sir.
Morning.
So I was reading a case that I saw in your book, Farmer Kinwa versus State. So the first part of the case, there was a quotation by the judge, Iyi Zoba, JCA. So he was trying to talk about the intention, the mens rea of the murder case. So let me quickly read what he said about it, because
is it related to the plea of, hold on, is it related to the plea of self-defense?
It's somehow related, but let me just read it.
Because hold on. We want the lecture is on self-defense.
Yeah, it is related somehow.
Okay. Oh yeah, quickly go ahead.
So he said, if therefore there's evidence that the appellant intended to kill or cause grievous bodily harm, and in consequence, the disease was killed by Section 316 of Criminal Code, the appellant is guilty of murder, as it is immaterial that he did not intend to hurt the deceased, unless he can rely on any defense, such as provocation, self-defense, or accident. So my question is in relation to the immateriality of the intention to cause. Otherwise, if not the self-defense, plea of self-defense and other ones, I really want to understand if it is only the plea of self-defense and the provocation and accident could give somebody a total exoneration from a murder crime. Because before now, we knew that the intention also can exonerate somebody from any.
No, well, intention, it's not as if intention is exonerating you. If you don't, in a murder, you must intend to kill. Yeah. And that intention to kill can be construed from a number of variety of circumstances. So if the court is able to construe intention to kill, then you are liable for murder. But if the court is not able to construe intention to kill, then the question is whether you are liable for manslaughter. What you have done, is it unlawful? What you have done, is it such a dangerous thing as to be able to endanger human life? If it is, then you are liable for manslaughter.
So my reason is for the judge to say it is immaterial that he did not intend. I don't know, because
you see, you can't. Sometimes they say some things which you may not be able to put together within the context. So let's leave that one. It doesn't relate to plea of self-defense. Okay, so next question. We again, Paula Emeka Ude, on mute.
Good morning, sir.
How you doing, Paula?
Fine, sir. You mentioned in your video that plea of provocation is reduced sentence, maybe from murder to manslaughter, and plea of self-defense is complete defense, that you'll be acquitted and you'll be discharged. Then in this case that was also mentioned, he was attacked by 3 men at night, right? And his his proceeds from his car were stolen. Then he used a knife to stab one of them, and that person died. And the court reduced it from, the court said that it was provoked, and he reduced it from murder to manslaughter. Then in another case, it was mentioned that once it is agreed that the person had reasonable ground to believe that his life was in danger, the amount of force used by the prisoner to preserve his own life becomes immaterial. So my question is, he was attacked by 3 men. Did he not have reasonable ground to believe that his life was in danger? So why was it a reduced sentence instead of full, complete defense of self-defense? I also want to ask, if it was, in the case I was a woman that was attacked by 3 men, would the verdict still be the same?
Now, yes, the guy you said that was attacked by 3 men who stole from him. Now, if he was attacked by 3 men and he brought out a knife and stabbed one of them to death, what was the nature of the attack? If they were armed, or they were trying to use arms, or they were trying to use physical force to overpower him, that may create in him an apprehension of death or an apprehension of grievous bodily harm that would justify him to bring out his knife to kill them, which will have, entitled him to a plea of self-defense. But it's really curious that you said the court found him, allowed him to rely on the plea of provocation, because if they tried to steal to him, what was the provocation there? What was the provocation there? I can't remember the true facts of that case, but it's a bit awkward, because if 3 people accost you at night, that ordinarily may create a fear of apprehension of death or grievous bodily harm in you. And if you have knife and you attack one of them and one of them dies, then you should be able to rely on a plea of self-defense. And that other case that you refer to, that says once a person is truly fearful for his life, then it does not really matter the degree of the amount of force. It's correct to the extent that, the court related that case. I'm sure that's the case involving those University of OAU students. The court related that case to the fact that, look, somebody is attacking you, wants to kill you. At that point, you have already, the threshold to activate the plea of self-defense has been reached. Now, once you start attacking, your mind may then be focused on achieving your objective, which is to eliminate this force, this threat, and to preserve yourself. So at that point, you can just go on and on. At that point, it becomes difficult to moderate your response. That's what the court is trying to say. But that doesn't discount the fact that the threshold must be reached. That threshold is that you apprehended, death or grievous bodily harm. Once you apprehend death or grievous bodily harm, the threshold is reached. Then you are now to use the amount of force that is required to overcome the threat. And at that point, because you started, the threshold has been reached, and the response has started. Then, because you said at that point, you can't then be talking of the degree again, because the threshold has already been reached. Because the man is now protecting himself. And so I think both can be reconciled. In that case, it's a bit awkward, because the facts would have suggested to me that the plea of self-defense should have availed. All right. Tovia Oj Abu, on mute.
Good morning, sir.
Please, when you have answered your question, please lower your hand so that, go ahead.
So I wanted to ask a question on self-defense as regard property. And when you were teaching, and also like in the section, it says that the person can use reasonable force as necessary, but then it also says that this force must not cause harm. And the scenario in my head is the situation whereby, let's say like a lady is walking home at night and a guy approaches her to steal her bag. And let's say she uses like maybe an object around her, like a rock, to strike him, and that causes serious harm to the person. So in that scenario, can we say like the force was reasonable? However, the section also says that it must not cause harm. So how do we like merge both, and which is correct?
Yes, that's a very good question. Now, when you are defending property, the law allows you to exercise your right to defend your property and to use some force to defend your property. But it says you must not do it. Actually, Professor Okonkwo and Nance, they have criticized that provision, that how do you stop somebody who is trying to steal from you by force, and you are using force and you will not do harm? That provision is innocuous. That what it should have said is that you should not do unnecessary harm. And there's an equivalent provision in the penal code that actually captures that you should not use any harm that is not necessary, but that you should not do any harm, you should not do no harm at all, is unrealistic. Okay, now in the scenario that you painted, somebody tries to steal from a lady at night. Okay, there are instances where your right to defend your property gets mixed up with your right to protect your person. Now, if your right to defend your property and the right to protect your person gets mixed up, then it raises the threshold of the kind of force that you can use to protect both yourself and your property. So if it is in the night, in a lonely place, the lady may feel not only the need to protect the property, but also the need to protect herself. But the use of force in that instance may be justifiable, even if it causes harm. Okay? So that is the way I can explain that. But for the provisions of the code that says no harm should be done at all, that provision is problematic. And I agree with Okonkwo and Nash that the provision of the penal code in that regard is preferable, because it says that it should not cause any unnecessary harm. I mean, somebody is trying to forcefully collect your phone from you and is determined to collect it from you, and you want to protect him from collecting it. I mean, a push or a shove in the instance may be appropriate, and that may cause some harm. Even a punch may be appropriate in that circumstance to prevent him, to overcome the force that he's trying to use to take your property. So you can unmute and lower your hand.
Wait, sir, I wanted to further ask something.
Okay,
so
go ahead.
If we were answering a question like in the exam hall as regards this, how do we now specify it as regards the provision, like the scenario you just gave of somebody trying to steal your phone?
Yes, you discussed it as I've said, and we said that, well, having regard to the fact that in this instance, the defense of property is mixed up with the defense to the person, then that will justify a higher level of force, which may cause harm, which may not necessarily be permitted if you are only trying to defend your property. Yes, that's the way to address it. All right, so let me allow Omole Emmanuel.
Good morning, sir.
How are you doing?
I'm fine, sir. I want to ask two questions, one after the other. So the first scenario is where a person is walking on the road, and let's say somebody else, a thief, comes and snatches his phone from his hand, and then the thief proceeds to run away with the phone. Then when the thief is trying to run away, the person whose phone was stolen stretched his leg to cross the thief's leg, and then in that process, the thief hit his head on the tarred road and died. Would there be any defense that can avail the person, and would the person be liable for manslaughter or murder, sir?
That's a very interesting question. Now, the thief has stolen the property and is trying to run away. So this is not a case in which the right to protect self is commingled with the right to protect property, because the guy has stolen the property and is running away, and the law says you can use force to protect your property so long as you do not do harm. In this instance, the victim stretched his leg, or the person that was from whom the property was stolen stretch his leg deliberately to bring down the thief, I believe, is not accidental. And the thief falls down, breaks his head, and dies. Unfortunately, he may be liable for manslaughter. He may be liable for manslaughter because the law says he can protect his property without doing harm. And in this instance, he knew that the guy was running away. He stretched his leg. That is something that is likely to endanger life. And in the context, that is also something that looks unlawful because the law says you should not use, force that can cause harm. So I think, unfortunately, he may be liable for manslaughter. And then the court will take into consideration property, maybe as mitigating factor. Use that not to take that into consideration, not to impose a sentence of two states. So Omale, bring down your hand. Bring down your hand. Bring down your hand. Grace Nanchi, you should know how to bring down your hand. Now, from the place you raise it, go there. You will see an icon that says "Bring down hand." Then you click it. That's it. Grace Nanchi, on mute. On mute.
Okay. Good morning, sir.
How are you doing?
I'm fine, thank you, sir. So my question has to do with Section 287 of the Criminal Code.
The one that deals with provoked assault.
Yes, it deals with self-defense against provoked assault.
Yes,
So
I've explained it earlier.
no,
Yes,
like there's a second paragraph. There's a part of the second paragraph I do not understand. So can I read
what
it
does
out?
it say?
Okay, so the
Yes.
second paragraph says, this protection does not extend to a case in which the person using force, which causes death or grievous harm, first began the assault, says the second word, but the part I don't understand is where I said, no, in either
read it
case.
complete. Read it complete. Don't
Okay.
read everything you are reading complete. You will see the answer there.
Okay, no problem. This protection does not extend to a case in which the person using force, which causes death or grievous harm, first began the assault with intent to kill or to do grievous harm to some person, nor to a case in which the person using force, which causes death or grievous harm, endeavored to kill or to do grievous harm to some person before the necessity of so preserving himself arose, nor in either case, unless before such necessity arose, the person using such force declined further conflict and quitted it or retreated from it as far as was practicable. So my question has to do with the part that says, unless before such necessity arose, the person using such force declined further conflict and quitted it or retreated from it as far as was possible. Does it mean that, like, in a situation, maybe the person that provoked the assault, the initial offender, maybe the person like made moves to assault somebody, but then the person stopped the assault and like retreated from it as far as was practicable, but then the other person that was supposed to be the recipient of the assault then attacked. In that case, I want to understand if what this provision say that in that situation, if the initial offender, right, assaults the second person like in self-defense and or like causes grievous bodily harm in defending himself, in that case it will be covered under this section. I don't know if you get my question, sir.
Now let me go over. And you see that in that video I tried to explain and explain again. Now let me try and explain the provisions again. Section 286 deals with unprovoked assault. Section 287 deals with provoked assault. Okay? You provoked somebody and the person responded. You cannot use your provocation as a basis for defense. Okay? You shot at somebody. You fired a gun at somebody. And the person shot back at you. And then you shot back at the person and killed the person. You're a murderer. Because you do not have the right of self-defense to the person shooting back at you in response. Because the person was defending himself. Okay? Now, let's now assume that You shot at the person. The person shot back at you. And you now discover that, wow, this guy also has a gun. So I can't be playing this kind of pranks with him. You now threw away the gun and say, okay. No more trouble. That's okay. I was just trying to tease you. That's all right. And the person continues to shoot at you. And now you are now the one that is a danger. You are now trying to run away. But and you are shouting, but I've thrown away my gun now. I'm not fighting again. The guy didn't answer. He continues to shoot at you. And somehow, you were able to get another weapon with which you overpowered and killed him. The defense will avail you. The defense will avail you because although you began the assault with the intention to kill, you had desisted. You had declined further conflict. So that's the scenario in which that thing operates. Now, the most important thing is that the law ordinarily will not allow you to provoke an assault and use that assault as the basis of defense. But if for any reason you have declined further conflict and you have moved away and the person is still insisting on hurting you and it's such a kind of hurt that can, cause death or grievous bodily harm, then even though you are the one that started the initial assault, then the law may be able to assist you. All right.
Okay, thank you, sir.
Yeah. Adao Lisa. Nwogu Chinelu Adao Lisa on mute.
Good morning, sir.
How are you doing?
Fine, sir. Thank you. I wanted to ask a question in regards to self-defense. If someone was getting like raped and somebody in the process of maybe trying to like rescue the victim, maybe hits the assailant on the head with a log of wood and the person dies immediately, can that person plead self-defense?
Yes, he can. He can.
Okay.
Because the victim can also have used the same amount of force to overcome the assailant. Yes, the person, when you are defending others, your right to defend others equates your right to defend, and the same rules apply. All right. Nwokocha Chiamaka, peace. Nwokocha Chiamaka, peace.
Good morning, sir. Good morning, everyone. So my question, I'm good, sir. I was going through the video, watching the video, and you said the following defenses are seen as justificatory. You said
you are going back to the first lecture.
Yes, sir. I'm not sure because I watched them. I didn't watch them in the order.
Okay, all right.
Yes.
Go ahead.
Yes, okay. So, but my question is very quick. So, for justification on the grounds of disciplining, maybe in school or at home, or for people who are local parents, or so, how about at the time? There's a time when Lagos State, especially in Lagos State, I think other states too, but in Lagos State, there was a ban on corporal punishment. So are they not two opposing laws? So because when you say there is a defense for this, like you can ask, you can seek self-defense, or sorry, you can justify
in discipline.
Yes, disciplining is a. So how about corporal punishment, laws against corporal punishment, especially in Lagos State? At least I know of that.
Well,
they are like two different.
At that time, it was not a law; it was a policy. It was a policy of the government. Maybe because they saw many instances in which it was abused, and the government now made a policy that no more corporal punishment in our schools. It is within the right of the government to do that. That does not affect the defense if a teacher now breaches that policy and inflicts corporal punishment on a pupil. Yes, they can discipline the teacher by sacking the teacher or removing him from the school, but he will have a defense of criminal liability. So that was just a policy. Okay. Abdul Fatai Patia Ayomide, on mute.
Okay, sir. Good morning, sir.
Good morning.
Can you hear me? Good morning, sir.
Good morning. Good morning. I can hear you.
Okay. So, sir, in the case of Minton and DPP, the man killed his wife with a gun, and then the court held him liable because his defense that he didn't have the intent to kill them makes sense. However, the House of Law acquitted him that he couldn't prove that he had the intention to kill. So I wanted to ask that, why was he acquitted? Like, his defense that, okay.
No. How does that relate to self-defense?
Sir?
We are on self-defense. Ask your question in relation to self-defense.
Okay, sir.
If you want to reframe the question, okay, let's go. Deborah Iyanolu, on mute.
Good morning, sir.
Good morning,
So my question is on the question that Emmanuel asked. So he said that if concerning a thief, that a thief stole the property of somebody. So the thief was trying to run away and he tried to use his leg to stop him, and the thief fell down and died. So I wanted to ask that, can't he rely on defense of accidents? Because under accidents, they said it must be an intentional act, but it did not expect the consequence.
Did he not put his leg out?
Hey, can you hear you? Hello, sir.
Did he not intentionally put his leg across to bring out? Hello, can you hear me?
Yes, I can hear you.
And I'm asking a question in return. Did he not intentionally stretch his leg to bring the thief down?
He did, sir, but he just did that to just stop the thief. He did not intend. He did not intend him to die.
He did not intend him to die. That's why he will not be liable for both. But what he did is unlawful and is capable of endangering human life. And a human life was endangered. The man died. That's why he will be liable for manslaughter.
Okay,
all right.
Thank you, sir.
So mute back. Abi Bonodikwe. I thought you asked a question earlier. Are you still interested in asking another question? You can unmute.
Good morning, sir. I haven't asked any question.
Oh, okay. All right. Go ahead.
Thank you, sir. I want to ask for still under this self-defense thing, that for someone who stabs like an assailant to defend himself or theirself, so how intense should the stabbing be for such defense to avail such a person? Because in your book, I've been trying to look for that particular scenario case.
It depends on the nature of the attack. Don't forget, the nature of the attack must be sought to create in the person raising plea of self-defense apprehension of death or grievous bodily harm. For instance, you are in your house, God forbid, in the middle of the night, and you are hearing armed robbers banging on the door, threatening, asking you to open the door. That if you don't open the door, they are going to kill everybody, or they are just banging on your door, trying to break your door open. I mean, that's enough to apprehend death or grievous bodily harm. If you have a gun and you bring out the gun and shoot at them, the plea of self-defense will avail you. So it depends on the nature of the attack. It is the nature of the attack that will determine the nature and the level of response. And if your level of response is commensurate and proportional to it, then the defense will avail you.
Okay, yeah. What I'm trying to ask specifically is that for stabbing, I heard somewhere, I think I read somewhere that when the essence of self-defense is just to stop the action of the assailant. So let's say, for instance, you stab the person once, and the person has like stopped due to your action to prevent yourself from harm. It is enough for you to have defended yourself. But going ahead to continuously stab the person, let's say 3 stabs or 4 stabs, is like despite the fact that you have apprehended some degree of fear of being dead, going ahead to continuously stab is like a kind of contradiction of some like it might not really agree.
It will depend on the facts and the circumstances. Like in that case involving those OAU students, the Supreme Court said, in a fight to the death, you can't begin to say which one is enough force. 2 people are fighting. Somebody wants to kill you, and you are fighting against one another. You may not even realize when you have stabbed him sufficiently to kill him. So I mean, it's a question of facts. If you stabbed him one time and that was enough to demobilize him and reduce and completely eliminate the threat, then the question may then be why the additional stabs. But ordinarily, if it is in a fight to the death, you can't be measuring the amount of force that the amounts of force that will be enough to overcome the assailant.
Okay. Please, I have another question, but not
quickly.
not necessarily about self-defense. I'm sorry.
No, it has to be self-defense.
It should have been in the last class you held with us, but because I raised my hand very
okay. If it was in the previous class, you can ask it. I thought it was just a general. Go ahead.
Okay. So there's this issue that recently happened where you talked about what was it called? An herbalist, where the purchaser of a particular charm from the herbalist wanted to test the charm being given to him by the herbalist. And for consenting one's death, in this scenario, the way it appears to me is that the herbalist did not actually consent to his being killed. He did not consent that he wants to be killed. It was on a different thing that, okay, you want to test the charm. And even the way in which you yourself, the way you pronounce this charm, said Ayeta, which shows that you kind of have some kind of understanding, although you might not be in that life, but you have some kind of understanding that this kind of charm really exists within the context of the Yoruba culture. That is, although the motive for the purchaser of such charm can be a different issue. But what I'm trying to like,
what is the issue? How does that relate to general principles of justification?
So I was just trying to say that what if it can be proved that yes, this existence of preventing like this precautionary, I don't know, trying to prevent yourself with charms exists within the Yoruba culture.
No, that will not avail. It will not avail. Bye-bye. It will not avail. Additional Kehinde on mute.
Okay. Good morning, sir.
Good morning, additional.
Yes, sir. When you were speaking the other time, you said something that if thieves, a gang of thieves, if they were banging on your door and doing all sort of things like they want to attack you and you pick the gun and you want to use it to attack them, that you will not be liable for murder. So I don't know, I don't really agree with that, because I think using a gun for just mere banging on the door
you should allow them to break your door, come inside your door and come and kill you. In the middle of the night, you are sleeping and
so I can't hear you.
You are sleeping and you are woken by 2 a.m.
Okay.
Armed robbers banging on your door, breaking the glasses, trying to break in. So If that does not create apprehension of death, then what will create apprehension of death?
Okay.
People merely hearing people shouting, ole, 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 thief, thief, thief in the night. It creates fear in you. When they now come to your door, to the front of your door, and start banging the door, trying to break in or trying to, remove the window, the burglar proof, and you say that is not enough to kill them. What will be enough when they come in and kill somebody?
Okay, sir.
Yeah. Okay. All the other people that I can see their hands have asked questions before. So I don't know whether they forgot to take down their hands or they still have another question. Ayomide, do you still have another question? If you don't, then I've enabled you to unmute.
Yes, sir. Thank you very much, sir.
Immediately you finish, bring down your hand so that if you bring it up again, I will know that maybe you have another question. Go ahead.
Yes, sir. Thank you, sir. So in the slides that you sent to the class, you stated that there are defenses to criminal liability, and one of them is it coercion? Yes. So as per Habib's question, this question is very ridiculous, sir, but I don't know. Is
it related to self-defense?
Yes, it is. It is. Like there's the defense of coercion and there's the defense of
we're not going to coercion today.
Okay, yes, sir. But then can somebody make a defense that they were under an influence to commit the crime that they committed?
Which influence? What kind of influence?
Like supernatural influence to commit the crime that they committed.
No, there's no defense don't to law like that. Which
Thank you, sir.
There's no defense like that. Akinyemi Precious, do you still have a question or bring down your hand? I've enabled you to unmute.
So
because I want us to go to the next defense.
I just want to ask, they hold you accountable for manslaughter. What's the punishment for manslaughter?
The punishment for manslaughter is life imprisonment, but the life imprisonment is the maximum. The court may grant a term of years, depending on how serious the offense is. So bring down your hand. Omole, your hand is still up. Do you have another question? I want us to go to.
Yes, sir. Yes, sir. Finally, you said what he did there, like he stretched his leg. What he did was unlawful, but is it not lawful since it's permitted under Section 294 and 289 of the Criminal Code to defend your property?
Well, you can defend your property, but it says you must not do harm. You can defend your property, but it says you must not do harm. Now harm is done. Okay, so I think we can go to. I think we have had enough questions on. We have had enough questions on plea of self-defense now. So let's go to the third video, which is on the defense of intoxication. We looked at the defense of intoxication, involuntary intoxication, voluntary intoxication, and intoxication as a factor in negating the subjective mental element in a crime. So if you have questions on intoxication, you can ask your questions now. Okay, Tovia, you can unmute.
Good morning, sir. So my question is on I have two questions, and the first one is that you said voluntary intoxication is not a defense if you are the one that intoxicates yourself, like voluntary intoxication. However, under negating the subjective element, when I was listening to them, I'm thinking, is this not still a defense? Because the lack of intent sort of reduces your sentence. So is it not still some form of defense? So I was a bit like confused on that aspect.
Yeah, it's a form of, it's like an exception. It's a form of defense. Because if your intoxication, even though it's voluntary, goes to show that you lack the mental element required for the offense, then you will not be liable. Yeah, so it's, I agree with you. It's a form of defense. That's why we have it under defenses of criminal liability. It is a form of defense, but you have to understand the context in which the defense appears. So you can mute yourself back.
No, so I still have another
question. Okay, go ahead.
Yes. And then also I wanted to ask that, so most of the examples that were given when you're explaining were like in situations of like death and like assault. But I was thinking like in the case of vandalism for voluntary intoxication negating subjective elements, does it also apply? So you are drunk.
Vandalism to destroy somebody's property.
Yes, vandalism of property.
You may not be liable for a crime if it is involuntary, but you are liable to repair the property you have damaged. Do you understand?
Thank you, sir.
If your drink was spiced unknown to you, and you began to
it was known like voluntary intoxication.
Oh, if it is voluntary, then you don't have a defense now.
Okay, I was asking that, does it like the situation of voluntary intoxication negating subjective elements, does it apply also in cases of like vandalism?
Oh, cases of vandalism. Well, it is a general defense. The defense is not restricted to any particular type of offenses. It only tries to address the mental element, okay, which is intent. So for as long as the defense, the offense involves intent, then you can raise it. You can raise it. Yes. Odunlami Rebilekun.
Good morning, sir.
Good morning,
Please, sir,
Odunlami.
okay, thank you, sir. Please, I don't understand that part you talked about basic intent and general intent. Like, I do not really understand what you consider that part. Thank you, sir.
Yes. When we were discussing intoxication as intoxication that can negate the subjective mental element of the offense, Section 229, subsection 4 of the Criminal Code says, intoxication shall be taken into account for the purpose of determining whether the person charged had formed any intention, specific or otherwise, in the absence of which he will not be guilty of the offense. Now, the question of whether an intent is specific intent or otherwise is not, there's no provision in the Criminal Code that defines what is a specific intent and what is an intent that is not specific. Now, but under the common law can help us there by providing some guidance. Under the common law, offenses of specific intent are offenses involving purpose or conscious desire by the offender. For instance, offense of murder is an offense of specific intent. Offense of killing is an offense of specific intent because it involves purpose or conscious desire. Okay? But apart from offense of specific intent, there are also offenses of other types of intent. Under the common law, there is the concept of general intent or basic intent. Like I said, we don't have this concept under our criminal code. But the criminal code uses the phrase specific intent or otherwise in section 29(4). That means that the criminal code understands that there must be other types of intent that are not specific intent. And the common law helps us to understand intent that are not general intent or basic intent. And under the common law, general intent or basic intent denotes the remaining types of fault that a crime might require, such as knowledge, recklessness, or negligence. So if the offense can be committed by knowledge, or recklessness or negligence, then voluntary intoxication may be a defense. That's what this provision is saying. Now, do you understand now? Oh, she must have muted back. So that's the explanation, Sha. Odunlami Remilekun, are you just raising your hand or you have raised it before? On mute. Okay, so there's nobody again. Now I posted a video yesterday. I don't know whether you guys have listened to it. The video was not meant to be a class lecture, but there was some aspect of it that relates to. Okay, let me enable somebody to unmute, and because I wanted to find out if you guys have been able to listen to the video. Ayola Layemi, have you been able to listen to the video? You can unmute. Ayola Layemi. You can unmute. Ayola Layemi. Okay, the person doesn't want to unmute. John Dikpe Ayomide, you can unmute. Well, the person doesn't want to unmute. Okay. If you have not, now I'm trying. Okay, there's Tayo Adekunle. Okay, you can unmute, Tayo.
Yes, good morning, sir. I saw your video on the decriminalization of libel in the criminal law of Lagos State.
When did you see it?
Sir?
When did you see it?
Yesterday. I saw it yesterday in the evening.
So, like I said, the video was not actually prepared for the purpose of the class, but it's also relevant to some of the things we had talked about earlier. You know, when we talked about the definition of crime and the criteria to justify criminalization. You know, why we decriminalized the offense of defamation was because we felt that the civil law has already provided a remedy, and that criminalizing it would, you know, amount to using too much, will appear to be excessive. So I think you should listen to it. Then also the legislative competence to enact law on criminal law. Lectures, I address that issue, but at least it's also an opportunity to listen to me address it very well, because it's a very technical area of the law, and many, even some practicing lawyers, may not fully appreciate you know, the points made in that video. So I think you should find time to listen to it. Okay, is there any other question? I'm coming. Oh, I still seem to see. I'm coming. Nwogba. Okay, let me enable you to unmute. Nwogba. Okay, unmute if you still have a question.
All right, sir. Good morning, sir.
Yeah, well done.
Okay. I want to ask a question with respect to section 29 sub 2 paragraph A of the Criminal Code, which says that a particular claimant, or let's say defendant, is allowed to plead involuntary intoxication, even if he does not know that such act of omission was wrong, or not even know that what he was doing by the state of intoxication, you know, caused his consent by malicious or negligent act of an person. So I want to know, how do we just oppose this position with the general notion that ignorance of the law is never an excuse? Maybe this person doesn't know
well,
that.
this one is not a question of ignorance. It's a question of, and it's not a question of ordinary ignorance. It's a question of an induced and ignorance caused by incapacity. The person is not just ordinarily ignorant of the legal consequence of his action, but because somebody had intoxicated him without his consent. And that intoxication has reduced his capacity, to be able to know what he was doing. So there's no conflict between it and the maxim that says ignorance of the law is not an excuse. This is not just ordinary ignorance. It's ignorance induced by incapacity, and that incapacity was brought on the offender by the malicious or negligent act of another person. Okay, so I don't see any conflict there. All right, so bring down your hand.
I still have one more question.
Okay, go ahead.
Okay, the question I have, touches on the intoxication as a factor in negating the subjective mental element of the crime.
Yes.
You painted a scenario of, let's say, two guys who went to a party, and maybe on their way, they saw a very ripe fruit and decided to shoot their shot. And from there, this one arguing that I was the first to see, I was the first to talk. And from the argument ensued, which led to either fights or kind of murder. And your rationale there is that, since we can't, establish that there was no pre-contemplation on the intention to kill, so this person can successfully, plead whether involuntary or voluntary intoxication as a defense. So my question there is this: so must we always, rely on pre-contemplation of an intention to kill? Can there be an occurrence of immediate, though this person is, within the influence of maybe the spirit of alcohol, is there no way that they can say that, yes, there is a contemplation to kill? Because
no, you see, there's no contemplation to kill. There's no contemplation. It's possible that somebody may suddenly come up with a decision to kill without having the plan to kill. Yes, that is possible. But in this instance, the fact that we said that there was no conflict or disagreement between them, they were very good friends. The event that occurred because of their intoxicated state. Okay? There was no opportunity, and he could not form an intent at that instance because he has already been incapacitated. And that incapacity affected his ability to form intention. He was not in a position to decide anything at that point because he was completely under the influence of the alcohol. He was completely under the influence of the alcohol. He could not decide anything. He could not think. He was acting under the influence of the alcohol, motivated, inspired, and empowered by the alcohol. So that is why, in this instance, that voluntary intoxication negated the mental element required for the crime. There was no way it could have formed the intention. Contrast that to that Ghanaian case of Owari, R and Owari. Somebody already had an issue with one of his colleagues. He now went and...
Sorry, sir, we can't hear you.
Well, I'm sure probably you are the one that is not hearing me. Okay, it could be the internet at your end. So can you hear me now?
Yes, sir.
Yes, I said you can contrast that with the case in R and Owari. The guy who had a dispute with his colleague, he now went and took alcohol to give himself Dutch courage. And there was evidence that after taking the alcohol, he now went about looking for that his friend. So he had to do something evil to his friend. The alcohol in this instance just gave him the courage to do it. So the alcohol did not negate the mental element, which he had already formed prior to taking the alcohol. Okay, so if you compare the two together, you will see clearly that, the defense makes sense. Okay, Daniel Joy. This is somebody who hasn't spoken today at all. Daniel Joy, you can unmute.
Good morning, sir.
How are you doing? Go ahead and ask your question.
I'm fine, sir. Thank you, sir. Say again. I'm sorry, sir. Can you hear me, sir?
Go ahead, go ahead. I can hear you live and direct.
Okay. Yes. So what if, for example, someone committed murder under duress? Let's say, okay,
What do you mean by what do
a
you mean by
guy
duress? No, what do
was
you mean by duress? No, we can't hear you.
guy like a gun is being like pointed at his head, and it's like, if you don't eject a third party
When we get to the defense of duress, we'll answer
with
that
this
question.
poisonous substance to
When
kill
we
him,
get
then
to
I'll
the
kill you
defense,
instead.
when we get to the defense of duress, we'll answer the question. I know the answer, but I'm not providing it now. When we get there, we'll answer it. So don't worry, we'll get to the defense of duress.
Okay, sir. Thank you, sir.
Oh, no, Deepa, do you still have a question? Your hands are still lifted up.
Yes, I think I just want to ask, like, get your opinion on something based on section
It must be related
to
to this lecture.
yes, yeah, under intoxication, sir.
Under
Same intoxication we're talking about.
Okay, go ahead.
Section 29, sub 2 of the criminal law of Lagos State 20, that like gives like an extension to the defense of intoxication by adding, like, I think, is it accidental act, like the defendant himself.
Accidental and mistaken act.
So I want to ask for your opinion that to what extent can we say that this section like permits crime to be committed under or permits excuse under intoxication, because it seems like to be too broad in a way for me. Because how can somebody intoxicate himself negligently and commit a crime? And
let me give you an example. You mistakenly had an overdose of a tablet. Maybe you didn't hear the doctor very well. The doctor said, take this tablet 1 time daily. And somehow you are talking on the phone. You know, when we speak on the phone, sometimes you think you are communicating with the person on the other side, and the person on the other side thinks he's communicating with you. But maybe because of a glitch or something, you are not actually communicating at the same level. So the doctor told you, take this medication 1 time daily, and you thought you had 3 times daily. So that's a mistake. Now, if you now take it and it's something that can intoxicate you, after you've taken the 3rd dose, you now became intoxicated, you lost your capacity, and you committed an offense. That's a mistaken scenario. So it would be unfair if the law did not create that kind of exception. Do you understand? You may not be able to imagine a scenario where there are circumstances in which it may occur, and it would look unfair if the law were to hold the person liable for an offense. All right. So I guess we'll probably stop the lecture here today. I think I've attended to everybody. So I will send the. So we've done intoxication now. So I will try and send the other lectures ahead so that you guys can prepare for the next class, which will be on Thursday. All right, so see you then. Have a wonderful rest of the day. Take care. Bye-bye. Oh, sorry, before I go, I've forgotten. Make sure you type your matriculation number and your name on the chat box. And then those who are joining us via YouTube, even on the YouTube, you can indicate your matric number and your names. Even on the YouTube, I will harvest both and match them together for the purpose of attendance. So I will leave this on now for another 5 minutes to enable those who have not put their names on either the chat box or on the YouTube to do so. Bye.